Hey, what's up, everybody? So, I wanted to take some time out in this series to talk about res judicata, right? So, basically, res judicata means that you can't continuously go back to court to litigate something that's already been litigated, right? So, I'm just going to get straight to the point and cut through the chase. I have some case law before me, and I'm just going to read it to you, right? So, res judicata, under the doctrine of res judicata, a final judgment on the merits rendered by a court of competent jurisdiction acts as a bar to subsequent suit between the parties involving the same cause of action, right? So, you've been to court already, there was a judgment, neither of the parties can come back and litigate that same case, right? So now, interestingly enough, and this was case law in Ryan v. David A., but I mean, there's plenty of case law that's going to say the exact same thing, right? So to take it a step further, basically, in res judicata, the bar extends to what was actually decided in the first action, as well as those matters that could have been decided in that suit. Let me read that again. The bar extends to was what actually decided in the first action, as well as those matters that could have been decided in the first suit. And I'm going to read it one more time. As well as those matters that could have been decided in the first suit. LaSalle National Bank versus the County Board of School Trustees, right? So I'm just going to read the same, essentially the same case law, but from a different case. The doctrine of res judicata provides that a final judgment on the merits rendered by a court of competent jurisdiction bars any subsequent actions between the same parties or their privies on the same cause of action, right? And then again, the doctrine extends not only to what was actually decided in the original action, but also on matters which could have been decided in that suit. So I'm going to read it one more time. The doctrine extends not only to what was actually decided in the original action, but also on matters which could have been decided in that suit. So this is pretty much straightforward. It really doesn't require that much of an explanation, and it really doesn't require any interpretation. You went to court one time and you shot your best shot and you lost, right? Now that you get out of court, you think of all these different ways of how you could have won that case, and now you don't have the opportunity to go back and do it all again, right? Using the new ways you thought of how you could have won that first case, right? So that's also known as a second bite at the apple. You don't have a right to go back to court so you can get a second bite at the apple. You only get one bite. Now, this is actually interesting with everything going on, that this is some pretty simple and straightforward concepts that basically apply in all cases. And I think for the most part, sometimes people try to get over because most people don't know about this, but it's pretty common knowledge in the legal community, right? So in a sense, I think sometimes prosecutors try to look for sophisticated ways of retrying the same case with the same set of facts so that they can get a second chance to win. And that's simply not allowed. And one of the doctrines that prevents people from doing this is called res judicata. And there's more to this. There's a lot more to this, which we're going to get into here in a second. But let me see if I can collect my thoughts, because I wanted to say something else, but I just kind of lost my thoughts and I'm getting thrown off here. So it's kind of like playing a chess game and realizing after you lost the chess game that if you would have made a slightly different move, maybe 5 or 6 moves ago, you probably would have had a better chance of winning the game. So you're asking your opponent to reset, to go back to the chessboard, reset up all the pieces as they would have been 8 moves ago, so you can have a chance to win that game. No, that game is over. That game is over and it's done with. You can't replay that game, right? I can't really think of a really good analogy to basically explain this. Well, let's look at this from another perspective. Let's take the playoffs, right? The playoffs for a basketball game, for example. And I really don't know that much about sports. But after the playoff is done, it's done. It's over with. The team that won. The team that lost doesn't get a chance to have them go back onto the basketball court another day and replay that game. It doesn't work like that. You either win or you lose, right? Now, with that said, there are ways for getting around res judicata. There are some limits to res judicata, but none of that is going to apply in this video series. And actually, if you have a situation where you're trying to get around res judicata, I may know some techniques that you could use to get around it. And not everyone has this option. I'll just say that, right? So I've already done one video series that talks about how to get around res judicata, but there's more to it that's not in that video series. And if anyone's interested in how to get around or how to defeat res judicata, there are a certain limited set of circumstances that will allow you to defeat res judicata. But if you don't have those circumstances, you can't beat it. And there's a few opportunities that everyone has that would allow them to beat res judicata, right? So if you're interested in me doing a video series on defeating res judicata, definitely send a donation and I'll definitely put that video series out there. But for the context of this video series, there's no need for me to provide that information, right? So just moving on, let's look at some other concepts or other layers of res judicata. So there are certain tests that can be done for res judicata. There's the same evidence test, right? And then it basically goes on to say, under the same evidence test, a second suit is barred if the evidence needed to sustain the second suit would have sustained the first suit, or if the same facts were essential to maintaining both actions. So I'm just going to simplify this. Are the facts that you're bringing in the second suit, were they the same facts in the first suit, right? If they're the same set of facts in the first suit, then res judicata is going to apply. Why is res judicata going to apply? Because we already read the doctrine extends not only to what was actually decided in the original action, but also to matters which could have been decided in that suit. So based off of reading that and reading the same evidence test, even though you may have slightly different facts, the only question is, were those facts available in the first suit? If the facts were available in the first suit, then res judicata applies. In order for res judicata not to apply, there would have had to have been facts that happened outside of the first suit that gave you the ability to create a new suit or a new lawsuit that has nothing to do with the first lawsuit. But if any of the facts that you're bringing in the second suit was available in the first suit, then res judicata applies. There's nothing you can do. You cannot bring a second suit. There's also another test, and it's called the transactional test. And it goes on to say the transactional test provides that the assertion of different kinds or theories of relief still constitute a single cause of action if a single group of operative facts give rise to the assertion of relief, right? So to me, they read slightly different, but honestly, I'm not seeing the difference because they both they both refer to the concept of the same facts, right? So you have the same facts in this one, and you have the same facts in this one, and then you have basically the same facts in this one, right? The only difference with the transactional test is that it's basically telling you you can't relabel something. You can't bring up new issues that were available in the first suit, right? It says the transactional test provides that the assertion of different kinds or theories of release still constitutes a single cause of action if a single group of operative facts give rise to the assertion of relief, right? So, yeah, that's basically what it's saying. You can't come up with new theories in order to retry the same thing. Whereas the other one is basically saying, are the facts the same? If the facts are the same, then you can't retry this case, or you can't, or it's basically saying res judicata applies, right? That's the same evidence test. And then the transactional test basically says that you can't come up with new theories for the same set of facts that was available in the first case, right? So that's pretty much it on res judicata. And like I said, at the end of this video series, I'm going to glue everything together and show you how everything really applies to, this situation. But, this is some pretty basic stuff in the legal community. And the general public is unaware of what the government is trying to do or what prosecutors sometimes do. And you can't, number one, bring a second case using same facts that was available in the first case. And then you can't, number two, relabel something or come up with new theories. You can't come up with new legal theories if you're using the same set of facts that were available in the first case. So that's it for this video. Please leave your questions and comments below, and please like, share, and subscribe.